focus on seniors. Today's topic is one that touches everyone's life in some way, planning for the future or protecting what matters most, our assets. So we're glad you're here today. And whether you've already started your estate planning journey or just beginning to think about it, right now, right here in this place, you're at the right place.
I am here today to talk to you about wills, trusts, powers of attorney, and other estate planning processes. Okay, who am I? Again, my name is Courtney Scollard. I'm an East Tennessee native, born and raised in Knoxville. In high school, I took dance classes at Maryville's own Van Meter School of Dance. Then I went to my undergraduate school at Carson Newman College, got my bachelor's degree in political science. Went on to the University of Tennessee College of Law, graduated from there in 2009. I was subsequently admitted to the bar to practice here in the state of Tennessee. In additional education, I've attended the Advanced Institute for Estate Preservation, put on by the Estate Planning Source, which I'll talk about a little bit later, in 2020 and in 2024. So, quick legal disclaimer, this presentation is for general educational purposes. It's not legal advice tailored specifically to you, it's legal information. Your attendance and participation here, or viewing it later on, or viewing it over Zoom or any of that, does not create an attorney-client privilege relationship with me, with Courtney Scollard. The information may or may not reflect your current circumstance and the current legal developments. If you're watching this, on YouTube 2 years from now, things may have changed. So it's not legal advice specific to your circumstances. You are encouraged to seek legal advice. You can contact me. You can contact any attorney you want to get specific information and advice for your circumstance. Myself, David Toper, who's a financial advisor who I also work with, and the Blount County Community Action Agency are not liable for any actions that you do or don't take based on this information today. You're here to be educated. All right, so a quick roadmap of where we're going to go today. I like to talk about things, and this is how I order them in the documents that I create and present to you as well. I go in the order that hopefully is what you'll need to use them. So first we're going to talk about powers of attorney and what that does, what it is, nomination of conservator, and then advanced directives, those end-of-life medical decisions. And that talks about both the medical power of attorney and what's commonly called a living will. After that, we'll take a quick little breather, and we'll talk about estate plans and the different types of estate plans that there are. Just a quick thing, there's the I have no plan, which is the state plan. You can have a will, a last will and testament, and that involves probate, or you can also set up a trust. And so we'll get into each of those. Okay, so words are important, and making sure that we all understand that a word means something when we use it is important, because that makes sure we know what we're talking about. So estate planning is the process by which an individual, you or your family, arrange the transfer of your assets, your stuff, in anticipation of death. So the estate is the stuff. It's the total of your property. Real property, which means land or houses, and personal property, everything else, not land, that's owned by an individual prior to distribution through a trust or a will. So if somebody's talking about the estate, it's what you owned when you passed away. That's the estate. A power of attorney, we'll get into that in a second, but it's a legal document that gives someone else the authority to act on your behalf, just like they were you. And then probate is something that's talked about a lot with estate planning. That's the court process that establishes the validity of your will or your no will, if you went by the estate plan. And it gives the authority to someone who is living to disperse your assets. All right, so families come in all kinds of flavors. The law assumes that a family is a man and a woman who marry. They have 2.5 children, thereabouts, and then each of those children then get married and have 2.5 children, and so on and so on and so on. However, we all know that that's not always the case. Sometimes a person won't get married, and that's fine. Sometimes they'll get divorced. They may or may not get remarried. Upon remarriage, there may be a blended family, or it just may be two single people. Sometimes people get married and don't have kids. Sometimes people have kids but don't get married. Sometimes you're raising someone else's kids, be it someone that's family, grandkids, nieces, nephews, or non-family. Then even if your family does fit the mold, if you got the 2.5 kids and so on, sometimes people don't die in the right order. You have children who unfortunately pass away before their parents. And you have sometimes in a couple, you'll have the sick person and the caregiver. And sometimes the caregiver passes away first, even though you've set up all your planning, assuming that the one who is sick would be the one to pass away first. So no matter where you fit in all of that, or what flavor your family is, it's important to at least look at these documents to make sure that they do fit, your wishes fit your family. So the first document that hopefully any of us would need is the power of attorney. Like I said, it's a legal document. It does need to be drafted by an attorney, and it's agreement, it's a contract between two parties. The person creating the power of attorney is called the principal. So if you're setting up a power of attorney, you're the principal. And then there's the attorney in fact, or the agent, who is the person that you are contracting with to be able to act on your behalf. When can a power of attorney be used? It's a living document, so it can only be used while you are alive. I like to say the document dies with the person. Because your power of attorney, your agent, can only do what you could do. And once you have passed away, you can't sign a contract, you can't take money out of the bank, you can't do all of these things. So depending on the type of power of attorney, it may or may not remain in effect if you're declared legally incompetent or temporarily or permanently disabled in a way that would affect your ability to make your own decisions. And the type of power of attorney I'm talking about right now does not direct healthcare. We'll get into that with the advanced directives. So some of the key words with power of attorney are durable. That's going to be a power of attorney even if you become disabled, incapacitated, or incompetent. A springing power of attorney has an event that triggers when it goes into effect. So let's say you're absolutely fine right now. You don't need someone else to be managing your bank account, signing contracts for you, those kinds of things, but you want to go ahead and set that up for the future. You set up a springing power of attorney and you can designate what that trigger event is. Powers of attorney can be limited either in time or in the powers. This is often used for things like international travel. If anybody has been in the military, oftentimes you'll have to sign a limited power of attorney that authorizes someone else to act on your behalf while you're out of the country. But also, a power of attorney can be limited in the powers that you're granting. If there's something that you just say, I don't want anyone else to be able to do X, we can write that in there. Then there's other powers of attorney. Some organizations do require their own specific forms, and a big example on that one is Social Security. If you're needing to communicate with Social Security on someone else's behalf, they have their own specific form. It doesn't matter what attorney drafted it, they're not going to take somebody else's power of attorney. Next, hopefully we wouldn't have to use these, but they do happen, is a conservatorship. A conservatorship is when a court determines that an individual is unable to manage their own affairs. This is either due to mental capacity, physical disability, age, or some other factor. And basically what it is the court is going to take you from being an adult and revert you back to being a minor. So when you're a minor, your parent or guardian has the authority to make the decisions over where you live, over what medical treatments you receive, over who you spend time with, where you can go, all of these things. And so this is a process where a court says, I know you're an adult, and I know you've been able to make these decisions, but you've now reached a point where you can't. And so they take away those rights, and again, it essentially reverts you back to being a child, and someone else is your guardian. Tennessee does allow for conservatorships over the person, over the property, being real or personal property, or over both. Tennessee also is, we have the ability to do a limited conservatorship. So if a person only needs certain things taken away, like, listen, as long as we can make sure that you're living in the right place and going to the doctor, you can make all your other decisions, that's an option with a Tennessee conservatorship. And what you can do is you can set up a nomination of conservator ahead of time. So right now, when you are mentally competent and in your right mind and able to say, if I reach that point, I want, Bob to be the one who takes care of me and makes those decisions, then you can create a document that says that. Now, it would still have to go through the court process, but the judge would look at that and take that into consideration that, oh, okay, well, when Susie was mentally competent and with it and knew exactly what she was doing, she said she wants Bob to be her conservator. So we're going to take that into consideration, and as long as Bob is, financially responsible, not a criminal, those kinds of things, and is willing to accept that role, then the judge will take that under a lot of consideration. And so with that, if that's something that you either anticipate or dread, going ahead and setting that up while you're competent can be a real peace of mind. Just you get to pick who's going to take care of you. All right, the next document is going to be the advance directive. These are the end-of-life medical decisions. An advance directive is a written document. It's a contract. It appoints both a power of attorney for healthcare, who's going to make your healthcare decisions, and in the past we've had the term a living will. And so that's when you designate what medical treatments you do or don't want to receive. And so the advance directive, I consider to be one of the kindest documents that anyone can fill out for their family, because it's you making the decisions of what you want to happen to you and your body at the end of your life. So you appoint who you want your medical power of attorney to be, who's going to make the decisions, who's going to talk to the doctor and say, yeah, let's keep going with a feeding tube. No, it's time to unplug. Yes, do CPR. No, don't. Those kinds of things. Little caveat, advance directive cannot have a provision for do not resuscitate. So if you're wanting a DNR or a do not resuscitate, that is a physician form that has to be filled out with your doctor. But this can go into effect of, like if you're in long-term care, you've had a stroke and you're non-responsive and these things, and then your heart stops, do you want CPR? That kind of thing. So yeah, it sets out 4 or 5 different scenarios of quality of life, conditions that people may or may not consider to be unacceptable. And again, there's no right or wrong answers. It's your body and your life. You get to decide, would I want to live in a persistent vegetative state? Would I want to live with end-stage chronic illness? And once you decide what you're not willing to, what would be unacceptable, what you're not willing to continue living with, then you designate what treatments you do or don't want. And so the reason I say this is one of the kindest things that you can do is by filling this out, your kids don't have to make those decisions. Your brothers and sisters don't have to make those decisions. Nobody else has to say, I don't know, would they want to get tube feeding? Would they want to stay plugged in? Those kinds of things. You get to make that decision. I've got some additional resources on there. That first website is the tn.gov. So in 2017, the Board of Licensing and Healthcare Facilities combined living will and advance directive. So this is the official Tennessee form. You can print it off online for free. You can fill it in on your computer, or you can handwrite it. Go get that, hand them out to your neighbors. It either has to have 2 witnesses or a notary. They've tried to make it nice and easy for people to get them filled out and executed correctly. Some other resources, these other 2 websites have just information about starting that conversation. Because again, your kids are gonna, or your family members, or whoever you've appointed as your healthcare agent, it's good to communicate what your wishes are with them, just so that again, they're not the ones having to make the decision. You've already said, this is what I want. All right, so take a quick deep breath. Observe the Grand Canyon. It's lovely. It's not my picture. I tried to find one, but I couldn't. So far, we've discussed the living documents. These are documents that are used while you're still alive, and in fact can only be used while you're alive. Like I said with the power of attorney, it dies with the person. Once you pass away, none of these documents have any effect. The rest of what we're going to talk about is going to deal with what happens after you pass away. And you may or may not know that a will, a last will and testament, has 0 effect or power until you die, because you can change your will up until your very last breath, as long as you're legally competent. So there's 3 general types of estate plans. Obviously, each of these is going to have like 100 different branches that go right under there. So the first one is going to be no plan. You don't have to have an estate plan, because the state, Tennessee, each of the 50 states actually, has passed legislation that dictates what happens to your stuff when you're gone. And I've included with this one also some DIY, things that don't involve like writing up an official document, but can affect estate transition without having to have those documents. The next thing would be a will, last will and testament. If your estate plan is based on a will, it will go through probate. That's the only way that a will becomes effective. And then there's trusts, which are kind of a hybrid instrument that we'll get into kind of what the differences are with that. All right, so if you have no plan, then you're going with the state plan. In Tennessee, and I believe all 50 states, this is called intestate succession. So it's your last will and testament. That's a testamentary estate. This is intestate, no will. And if you don't have a plan, if you're going intestate, your family will most likely have to go through probate at some point. And so this is where your family tree comes in. So if it's just you, then we're going to go down the tree first, and then around. If you have a spouse, then you may assume that everything's going to go to your spouse. However, in Tennessee, if you have a spouse and children, the surviving spouse gets 1/3 or one child's share, whichever one's bigger. So if you've got a spouse and a child, then it would go 50-50. Your spouse would get half of your estate, and your child would get half of your estate. You got 2 kids, we're going to divide it by 3. So everybody's getting 1/3. So kid A 1/3, kid B 1/3, spouse 1/3. Well, then you get into 3 kids that we would have to divide it by 4, and so it's going to be that the spouse gets 1/3 still. So we have 2/3 that gets divided amongst those 3. So we get into all kinds of complicated math that happens with this, but that's the order that the court will look at things. Spouse and kids, grandkids. Then you go up to parents, out to siblings, down to nieces and nephews. Oh, we still haven't found anybody? We're going to keep going. So those can get really, really interesting. That's if you have no plan. So here we see why it's good to have at least a little bit of a plan. There are certain things that you can do that don't involve a will that can settle your estate. You can have a payable on death designation. This is allowable for pretty much anything other than real property. That's going to be land, houses, things like that. But you can go to your bank account or go to your bank and say, hey, I want to add a payable on death. And that way you still own your bank account, but it sets it up so that, let's say you've got 1 kid and you want to make sure that they get it quickly and easily. You add a payable on death, and all your child has to do is show your death certificate and their ID, and probably sign some documents with the bank. But that would automatically transfer to whoever you've designated as your payable on death. They would automatically be able to receive those funds without having to go through court. You can do this for beneficiaries on financial products, life insurance, annuities, IRAs. All of those operate outside of probate court. And so that's something where, when you take out a life insurance policy, you have to name a beneficiary. Make sure you've got alternates on there. That way, it's all set up, so none of that has to go through probate. Now, when it comes to land and other things, joint tenancy is an option. Oftentimes, if you are married, you and your spouse will own property jointly. If you look at the deed to your home, it probably says, Bob and Sue as husband and wife, things like that. And what that means is that when one passes away, the surviving spouse or the surviving individual automatically owns that property 100%. Now, you can add a child or another relative as a joint owner on your property, but be aware that there are certain risks with that. Adding somebody else as an owner on your property does make them an owner of your property. So that opens up your asset to any kind of liabilities or debts that person might incur. So if they're in a car accident and there's a big judgment against them, if they file bankruptcy, if they get divorced, those kinds of things. it could open your property up to at least having to explore what kind of liability is there. If you do this, it could also be subject to gift taxes or capital gains taxes. So if that's something you're considering, definitely talk with an accountant. And then there's also control issues. You're no longer the sole owner of your property. So if you need to sell your house, but your child is like, well, that's part of my inheritance, I don't want you to sell it. They're a co-owner now, so they have to sign off in order for you to sell it. So just things to keep in mind. That can be a good thing, it can be a bad thing. The most common form of estate planning is going to be the last will and testament. It's a legal document. It does not necessarily have to be prepared by an attorney, but you definitely want to talk to an attorney to find out what those rules and requirements are. Like if it's handwritten, there has to be certain things that are checked off for the court to accept it as a valid will. The nice thing about a will is that you can go outside of the state plan. You can jump around in that family tree on where you want things to go. You can include stepchildren or non-family members or family members that are outside of your direct descendants, grandchildren, nieces and nephews, things like that, who would not automatically inherit under the state plan. You can also exclude someone who would normally inherit as part of your estate. If you have a sibling or a child who is estranged and you don't want them to get a third of your estate, you can leave them out using a will. And with a will, it must go through probate. The only way that a will takes effect is to take it to court and open a probate and have it administered that way. Probate is a court process that validates your will. The judge and the clerks look at it and they say, yes, this is a valid will, and yes, we are going to distribute based on the instructions here. In your will, you have the opportunity to appoint a personal representative, but anyone can petition the court to open an estate. So if you have, a debt out there and don't want to open, there's a probate that doesn't want to get open, the creditor can petition the court to open an estate so that their debt can be settled. So it's not just that distribution of your assets, but it is also settling any debts that you may have outstanding. In Tennessee, there's 3 kinds of probate. There's a full probate, which deals with real estate and assets, and that's typically what's going to the process that people are going to use. There's a small estate if you did not own any real property, land or a house, and the value of all of your personal assets is less than $50,000, then you can open a limited estate, a small estate, and that goes a little bit quicker. And then there's something called muniment of title, and that's if the only asset you have is land. And so, talking about the full probate, typically it's going to take 1 or 2 years to settle, even in the easiest cases. It takes a minimum of 4 months to settle because you have to publish that an estate is opened so that any of your creditors can say, hey, I want to file a claim. And they go down to the court and they file a claim and says, so-and-so's estate owes me $50,000. And so then your personal representative gets to go to court and decide if the judge will decide if that claim is valid, if the creditor is going to get paid in full, and that's going to happen before any of your assets get distributed to your heirs. I mentioned with that the publication. Probate is a public process. If you're really bored and want to go down to the courthouse, you can say, hey, I want to go look at some probate cases. And you can read somebody else's will, and you can see what documents have been filed. Because anybody can do that. If you can get in the courthouse, you can look at all the probate files that you want to. So if privacy is an issue that you don't want random Joe Schmo down the road to be able to go look at your will, then probate may not be the best option for your estate. In Blount County, the cost just to open probate is $386.40 this year. It can always go up. And that's just to file the petition to open probate, and it includes the publication fee. So they publish it in the newspaper. So then you're also going to have attorney's fees on top of that, most likely. And if you own property in any other counties, probate has to be opened in that county as well in order to transfer the asset. So the probate court only governs the county. They only do their county. Same thing if you own property in another state. Let's say you've got a vacation rental or a vacation house at the beach. Your personal representative is going to have to head over to South Carolina, file, and get all of that transferred. Now, probate can be an excellent thing because it does provide judicial oversight. The judge is going to make sure that everything that happens in probate is, by the book. Trusts are growing in popularity, and it's kind of a hybrid option. A trust can be used while you're alive and to direct your estate after you pass away. And there's many different types of trusts that can be used for different purposes. And there's really no one-size-fits-all when it comes to trusts. They're all very customizable. Okay, so a trust is a written document. It has to be written down. It's a contract. You have your trustor or grantor. That's the person who's setting up the trust. You. You have your trustee, depending on the type of trust and where you are in life. That might be you, or it might be another individual. You've got your trust property. That's your stuff, your assets that are titled in the name of the trust. And then in the document, you've got instructions for while you're alive and instructions for after you die. And then you've got beneficiaries. Who's going to benefit from the trust? All right, so there's our definitions. So your trust is going to be like a bucket. You're the trustor. You own the bucket. And you're going to put your assets into the bucket. So let's say you have your house. You change the title into the name of your trust. It's in the bucket. You got a vacation property. Putting that in there. Bank accounts, investments, retirement funds, things like that. You change the title or the beneficiary, put it in the bucket. A business, you can put a business into a trust. If you own your own business or if you are part of a partnership, there's extra steps that go into that. Other heirlooms, jewelry, art, if it has title, you can put it in the name of the trust. So now you've filled up your bucket. And the trustee is going to be the person holding the bucket. Like I said, depending on the type of trust, you might be the trustee while you're alive. So you've lost no control over any of this. And the trustee has the bucket and the list of instructions on how everything in the bucket is going to be distributed and used. So while you're alive, you might be the trustee. You might have full control over all the things in the bucket. But if you become incompetent or disabled, or once you pass away, then you've named a successor trustee in your document, and that person can automatically come over and pick up the bucket. There's no court process, there's no delay. They just pick up the bucket. And they've got your instructions. If you're still alive but incompetent, they've got your instructions for how everything in that bucket is to be used for your benefit. Or once you've passed away, they've got the instructions for how everything in that bucket gets distributed. One of the advantages with this is that the time limit in distributing everything from a trust is very long. So if you're looking at assets that you want to hang on to for grandkids, things like that, the official law is 21 years past a life in being. So anyone who's alive, so let's say you've got a great-grandkid who's like 1 right now, and you've included them in the trust can stay in effect for 21 years after your 1-year-old great-grandchild passes away. It can last a long time. So it's not like probate where you want to get things closed and you're looking at 1 or 2 years to get everything distributed. Well, maybe 1-year-old great-grandchild doesn't need to get $10,000 right now. Another advantage with trusts and that longer time frame is that you can set up stipulations for when and how your beneficiaries are going to inherit. You can set up age restrictions. A lot of times we'll have things like if we're talking about minors or young adults, okay, they'll get a third at 25, at 30, and at 35. That way you're not giving an 18-year-old a full inheritance. You can also set up stipulations for like graduating from college or trade school or something like that. You can say they can get this when they get married. Or there can be restrictions for if there's any kind of substance abuse or gambling or things like that. It says, okay, you have to be clean for X amount of time before you can receive anything from the trust. So those are some of the sort of how a trust works and some of the benefits. This is a quick little side-by-side on the differences between a will and a trust. Wills go through court, trusts don't. Wills take a year or two before you can even start distributions. A trust you can distribute immediately. A will is public. A trust is completely private. There is no reason for a trust to be open to the public at all. With probate, you've got the court, you've got probate fees, you've got attorney fees. it opens the door to be contested because you have to publish that, hey, there's an estate that's open, does anybody want to file something against it? With a trust, there's no probate. The only way that somebody can contest it is contesting the validity of your trust. And there's usually some sort of no contest clause that says, like, and if they're wrong, then they don't get anything. And again, it's totally private and can be family controlled. So the revocable living trust is one that's really gaining popularity because it lets you maintain control of your property and your assets while also going ahead and setting it up to avoid probate, avoid conservatorship, protect your privacy and things like that. It's revocable, so it can be changed. As long as you're competent, it can be changed. It's not just for the rich and famous. You know, a lot of times people hear trust, and it's like, yeah, I don't have enough to do a trust. Just about everyone could benefit from a revocable living trust. Now, I have come across some clients who don't, and I straight up tell them, like, there is no reason for you to shell out the money to set up a trust. And so yeah, revocable living trusts are great. And it has a provision where you can preserve the estate tax exemption when the first spouse passes away. So you don't have to take it immediately. You can wait until the second spouse passes away and you know, be able to manage the estate taxes in a better way. With that, I would say that you owe it to yourself and to your family to consider a well-written revocable living trust, or at least to look at all the other documents that I have discussed today.